Nigerian lawmakers want immunity for some of their own, just like what the president, governors enjoy. We'll find out what that means. And the Supreme Court will tomorrow consider the application by the APC to review its judgment over the Bayelsa State governorship seat. What are to expect tomorrow? Hello everyone and welcome to the program. This is Politics Today live on Channels Television. I'm Sean Kimalia, Channels Television's global headquarters here in Lagos. So much to talk about tonight, but limited time. But let's try our best to serve you some of the juiciest and some of the hottest stories in the land. So tonight, let's kick off by bringing you up to speed with some of the political stories that we're following for you on our political roundup.
A federal high court sitting in Abuja sentenced former PDP spokesperson Mr. Olisa Metu to 7 years imprisonment. Justice Okonabank found Mr. Metu guilty of all 7 charges brought against him by the Economic and Financial Crimes Commission in his trial for money laundering. He sentenced Mr. Metu to 7 years imprisonment for counts 1, 2, 4, and 7, 5 years imprisonment in respect of count 3, and 3 years imprisonment of counts 5 and 6. He, however, ruled that the sentences shall run concurrently, which implied that he would only spend the highest number of years of jail term, which is 7 in prison. The judge also directed Mr. Metu to pay a fine of 375 million naira to the federal government. Members of the Kaduna State House of Assembly have elected Honorable Yusuf Zailani as the new Speaker of the House. Zailani, who represents Ikabi constituency, was until his emergence the Deputy Speaker of the House. He was appointed on Tuesday after the former Speaker, Honorable Aminu Shagali from Zaria, resigned his position. The Court of Appeal sitting in Ibadan has fixed April the 1st for hearing on the appeal filed by the Oyo State government, challenging the court order not to dissolve the 33 local government chairmen and 35 local council development areas. The adjournment followed withdrawal and striking out of 3 different applications which the lead counsel to the respondent, Adeni Akintola SAN, had earlier filed, which the justices believe will stand as an obstacle to the main substantive matter. Displeased at Akintola's move, but noted that he would not oppose the application, the 3-man panel headed by Justice Jim Abada thereafter granted the application for extension of time till April the 1st, 2020. Kano State government says it will continue with the investigation of financial misappropriation of over 3.4 billion naira started against Emir Mohammed Sanusi II. Executive Chairman of the Kano State Public Complaints and Anti-Corruption Commission reaffirmed this while reacting to the ruling of the Federal High Court Kano that quashed the interim investigation report.
So let's get started, everyone. We'll probably touch on one matter, which may be our sub-main topic tonight on the program. So we're preparing for tomorrow's hearing at the Supreme Court, where the apex court of the land will be hearing the application filed by the All Progressives Congress APC, seeking, among other things, a review of its February 13, 2020 judgment disqualifying the party's candidate in the last governorship election in Bayelsa State, Mr. David Lyon. In the application filed on February 20, 2020 by his team of lawyers led by Mr. Wole Olanipekun, a senior advocate of Nigeria, the APC wants the Supreme Court to set aside some portions of its judgment. They include where it, quote, wrongly held that the Federal High Court disqualified its governorship candidate along with its deputy governorship candidate, and where it held that joint ticket of its candidate was vitiated by the disqualification of the deputy governorship candidate, and that both candidates are deemed not to be candidates in the election. The party is also asking the Supreme Court to set aside a portion of the judgment where it ordered INEC to declare as winner of the governorship election candidates with the highest number of lawful votes, and where it ordered INEC to withdraw the certificate of return issued to its governorship candidate and the issuance of fresh one to the candidate who had the highest number of lawful votes. What does this mean for our democracy, our elections, and the Nigerian judiciary? Let's get some views on this one. I have joining me from our Abuja studio, Professor Josh Amputon. Thank you so much, Professor, for joining us. Let's get your quick view on what this means tomorrow when the Supreme Court. This is not the only case. The case in Imo State is one important. The case in Zamfara is another one. But Professor, what do you make of what will happen tomorrow in the case of Bayelsa?
You see, a case that is pending in the court, there is an extent to which you can comment about it. And there has been spate of applications before the Supreme Court to review final decisions already given by the court. Now, we are guided by the provisions of the Constitution of Federal Republic of Nigeria, 1999 as amended. And Section 235 of that Constitution provides in explicit and clear language that the Supreme Court is the highest court in the land and is also final. Therefore, as a final court, it has only very, very narrow and limited jurisdiction to review itself. We talk of the concept of judicial review. Now, the popular parlance and jurisprudence is that the courts can review the legislative and executive organ. And then the question is whether the court can review itself. Of course, the hierarchy of appellate court. Sometimes you start from the trial court, it goes to the Court of Appeal, and it travels to Supreme Court. Now, having gone through those stages, it is expected that the decision of the Supreme Court should be final. But there are some provisions in the law, especially under the Supreme Court rules of 2014, especially Order 8, Rule 16, which says that the Supreme Court shall not review itself, save in situation where there is an error or where there is a slip, or where the Supreme Court judgment, as pronounced, did not really represent its intention, and therefore there is a need to bring the judgment to represent the true intention of the Supreme Court. Now, the provision did not say the intention of the parties, but rather the Constitution provides that Supreme Court judgment can be reviewed by the same court if that court that decision did not represent its own intention. So if the Supreme Court is a discretionary matter, if it goes to the Supreme Court and the Supreme Court is of the view that there is no error, there is no mistake, then the judgment will stand as it is. Because it is a limited and very limited jurisdiction that the Supreme Court...
Professor, yes. Section 235 you were talking about talks about the finality of the determination of what comes out of the Supreme Court. But in this sense of the Bayelsa, I read out some of the grounds in which the APC is applying for a review at the Supreme Court. On those grounds, do they look like what you have cited in the rules of the Supreme Court?
Well, basically, the reason for the review of those cases, they are very clear. Let me recall that of Imo State, for instance. In Imo State, there has been agitations that the addition of figures by the Supreme Court, or the Supreme Court did not take into consideration the necessary provisions of the law. You know, the Supreme Court is final, and it is final not because it is not because it is infallible, but it is infallible because it is final. So most of the grounds that are now being relied upon without having to comment on the case is purely for the Supreme Court to decide whether the decision as rendered in those cases represent its true intention. And where it represents the true intention of the Supreme Court has no jurisdiction to review itself.
Wow, interesting. Let's ask another senior advocate on the program tonight, Mr. Yemi Kande Johnson, who joins us via Skype. A quick intervention from you. What do you think the implication of this is for our democracy and our election?
Well, it's a momentous occasion because the Supreme Court has been asked to do something that is exceptional. If I might take exception or disagree with the previous speaker, this is not an application that is being made on the ground that the Supreme Court has made a slip or that the decision does not represent what it intended. The power that is being invoked in these cases is the power of the court to act ex debito justitiae, that is, out of the necessity of justice. A decision has validity, a decision of any court has validity as a judgment only if it fulfills certain fundamental conditions, that there was no bias, that it was acted within jurisdiction, that some fundamental issue of law or of fact was not sidestepped. This is a well-established principle and process of law. I myself argued a similar case in Alao and ACB before the Supreme Court in 1998, and the then trending decision was the decision of the House of Lords in England in the Pinochet case, where a challenge was made to the decision of the House of Lords in England, which is the final court as well, on the basis that one of the judges was biased, Lord Hoffman, and that bias would affect the validity of the judgment. If that was held to be true, the judgment should be set aside. And in that case, it was. In the case which I argued, Alao and ACB, they recognized the principle, but they did not set aside that decision. But the power is quite clear. If there is such a fundamental defect in the process of adjudication in which a case has been decided, then any court has a power, ex debito justitiae, that is the Latin for out of the necessity of justice, to review it and to set it aside, because the purpose of a court is to determine cases according to law, according to justice, and where it has jurisdiction. So I don't know what will happen tomorrow, but it's a difficult question, and I believe that the lawyers who are going before the court understand that they have to reach a very high threshold.